platform. So we'll do a roll call of my fellow commissioners. Commissioner O'Brien.
I am here.
Commissioner Hill.
Present.
Commissioner Skinner.
I'm here.
And Commissioner Maynard.
I'm here.
And we'll get started. This is public meeting number 388. We did just have a very productive agenda setting meeting, so I apologize for being a little bit tardy. We just needed to take a couple more minutes for a break. We're going to get started today. We have a single item on our agenda, and that is the review of draft application for license to hold or conduct a racing meeting for future applicants. And we've got on hand our general counsel and Dr. Lightbound, Director of Racing, and our Chief Veterinarian. I thought that we've had Counselor Grossman go through this document in the past, and rather than have him frame out many of the issues, I thought that what we could do is start with our asking questions or sort of general observations, comments, questions that we have about what we've received. We have in our packet the application. We have public comments that were submitted in writing to us. We also had the benefit of a public hearing where we had two members of the public give oral commentary, which one did reduce to writing for us. And now I just thought before we actually go through the application itself and ask both Dr. Lightbound and Counselor Grossman and team questions, just what are our sort of bigger issues that we want to ask of the team? Does anybody want to start? Otherwise, if it's helpful, I'll start. Commissioner Skinner, did you want to start or with anything, or are you going to?
Good morning. I don't mind starting. Where I would start, Chair and Todd, is just with an inquiry. Have we proposed any changes to the application in response to public comments that we've received since we last saw the application, or even, the one that is included in today's packet?
No, Commissioner Skinner, the draft that's in the packet is the same draft you've previously seen. Of course, we have received a number of comments, and I think those should be obviously considered for amendment, but they haven't been incorporated in yet.
And is that what the expectation is for this meeting?
I think if it's helpful to Todd, I think maybe we could even start, if we outline some of the issues, maybe we could go through what we have. And if we have a consensus on a couple of the more policy directives versus we also got some helpful red line edits, maybe that's a good exercise, Commissioner Skinner, for us to do to help move this along.
Sure.
Okay.
Before we do that, can I just throw something out too, that have we contemplated how, if at all, this needs to change given the recent sports wagering legislation? Because to me, voting on something that we know it needs some sort of, we need to address that at this point. So
this is reserved for vote today. I think.
I don't think I'm going to do that
right,
today. That's a big question mark for me. And then.
And I
just
think
throw that out before we dive in to the weeds.
I think absolutely, as we go through the sections, and if we can get to that global question to ask Todd. So right now, incorporating the public comments, the impact of sports wagering law, and any other general, both general and also of import. And it doesn't have to be so important, but if you just want to understand generally anything. Commissioner Maynard, Commissioner Hill.
I would just drill down on Commissioner O'Brien's question. There's the broad sports wagering, and then there's actually the specific sections that deal with horse racing. So I'm interested in both the broad and the specific.
Okay, good.
Same here, Madam Chair.
Okay. I'm also interested in both of those two. We have had the benefit of, in the earlier public meeting, delivery of a legal framework that actually serves as a foundation for us to even be engaging in this conversation. And we've also had the benefit of a silent briefing where we can't ask any questions, but we did receive, again, an update on the legal analysis. I think because the complexities here and also the stakes here, that it would be important to memorialize that legal guidance. It's an odd construct to ask your legal advisor to memorialize legal advice in public. We've been advised by the AG's office, I understand from Councilor Grossman, that that is how we have to receive legal advice, that we can't do it through an executive session. This has already been put out in the public forum, but if we could memorialize it in a document, that would be really helpful, so that if and when we do vote on this, we are we have a clear understanding of the legal foundation. Other general questions? Then we'll go through the section by section, and that would be again and ask questions as opposed to sort of, having it. I think it'll be more organic if we turn to our team members and say, even if it's, what does this do? That would be okay. What is this? If you have specific questions or even just a broad question that you don't understand the overall section. I really invite everybody to participate in the discussion. Why don't we do the easier one first in terms of the public, well, it's not necessarily easier, but it's maybe more concrete. On looking at the public comments, does everybody have access to what was included in the packet? The first public comment I have starts on, well, it actually has, it is public comments page 1 of the packet. And that's a letter from Butters Brazilian LLP. And it provides some general narrative and then it attaches a red line. Mr. Skinner, would you like to tackle the red line first, maybe in terms of thinking whether some of these are good ideas? I know this sounds a little bit like we're doing work, but I think this is moving the conversation along because we do not have a revised application in front of us that reflect these public comments for us to decide whether or not we want to move forward. I think, Todd, you should say, interject, this is a good legal, this is good for the legal, for the document itself. Interject. Mr. Skinner, do you have it or should I move it forward?
I mean, I have it in front of me. I think the substantive comment sort of feeds into the larger question of the implication of the language in the sports wagering bill relative to simulcasting. So, and there were a couple of comments relative to that from the public. So
the parking lot and then talk about the sports wagering piece as the second part of our discussion and do maybe the more straightforward public. Well, some of the public comments also include some policy discussions. So if we could just park sports wagering and simulcasting. So the very first one in the narrative is about section 8, and that is exactly, I think, Commissioner Hill, that's what you were referring to when you said you agreed with Commissioner O'Brien too. And so if we go to the actual red line, these are some just nuts and bolts. I'll help out here for, Pat Hanley made a suggestion instead of application of, a name of the applicant. Are we good with that? Okay, let's make that change. It says in calendar year. 4 calendar year, that actually may have legal implications. Do we need to be thinking about that? Oh, actually above it says location, he adds that in parentheses.
I think the current language is probably sufficient there to mean location.
Hmm?
I'm sorry, I couldn't hear you. I had an alert go off on my computer. Just Commissioner Maynard, could you restate that? I couldn't hear you.
Oh, I apologize. I said, I think that the current language it's very clear that it means location.
Okay, we don't need location. Yeah, okay. The next one, I agree, that's up for grabs, right? The next one, in or for calendar year, is there a legal implication on that?
I suspect so.
Yeah.
And I think that the 4 is leading toward what they're advocating, the interpretation they're advocating for. And I think the in puts a lot of restrictions on their ability to advocate. So that word choice, while small words, is I think something we need to talk about.
So we actually do address this, of course, more squarely later on in the application. It's not necessary to include it here. It could cause confusion based on just this limited conversation. So I might recommend we just remove it here and address it later on in more detail, where we ask specifically about the intention for conducting actual live horse race.
So you're saying remove that entire line from that part of the application?
Yeah, just on the front page. I mean, you know, it could, as I said, just cause more confusion than it's worth, because we do address it later on as well.
Was there a reason it made it into the initial draft, Counselor? You have to forgive me. Started.
I'm sorry, Commissioner, I didn't catch the beginning of your question, but
Is there a reason it made it into the initial draft?
oh yeah, that's a great question, and if I may, this whole thing was generally modeled after the existing application, and that's kind of where we started, and that's, I believe, just how it reads on the existing application. It wasn't intended to really address the issue that's being discussed now. As I said, there's another place in the application where we really are getting at when actual racing will be conducted, and this was not the place that was intended to be addressed.
Understood. Thank you.
But I mean, just to set the stage, that is a critical issue, is when will live horse racing be conducted? So I mean, for that reason, I guess in sum, I would say we might not want to include this here because it could be read in different ways.
Could we say anticipated? I mean, don't we, I guess that they're going to give us narrative in the application, but upfront, doesn't that matter?
Well, I'm wondering if we at least say date submitted, because that's a factual issue.
That's
And
the-
really what happens from there is our interpretation of what we can do in the year following that date. So maybe so the cover sheet is clear, you write whatever the date that's going to be submitted, that's the date that's on the face of it, so that it's clear to us as we're going and looking at these, that this application pertains to, was submitted in, 2022.
I think that makes good sense. We can change that to
You just say like date submitted, and then at least on the face of it, we know.
Any questions on that? Commissioner Skinner, Commissioner Hill? Let's put a little asterisk about that, just sort of as we go through the application today, whether we can circle back to this.
I'm wondering, is there a way to do track changes that's just a different color, Todd? So that we know what we suggested as possible changes during this meeting?
That'd be great. This is, of course, these changes I remember Pat handling. This is public comments. This is only
Right.
public comments.
But I'm
Caitlin?
saying, is there a way, Caitlin would just clear her throat, yeah?
I was just going to say, I've been taking notes on the conversation, but I guess I can go in, Todd, I can probably go into the Word version and track change it, right?
Yeah, I think so. And I'm doing the same. So yeah, I think we will obviously produce a document for your review after that, recognizes all the comments that were made.
Well, I think that that's really important. It's
Of
going to
course.
save you having to come back and look at this hearing. So to the extent you can do it simultaneous, it's really good. If we could just put an asterisk next to this, because I'm wondering if I might become better informed as we go through the application as to whether there should be a flag as to the intention of conducting racing, the actual time. Next is, and Commissioner Skinner, I don't know if you pulled it up, but I'm happy to have you go through it. But the next is, he makes a suggestion to clarify for a new applicant, a surety bond may be submitted prior to racing, but not at the time of the application. Counselor?
Oh, go ahead, Todd.
Oh, go ahead.
Well, Caitlin, feel free.
I was
We're
just
both
gonna,
counselors.
for this particular point, it's obviously up to the commission if you want to adopt language similar to this. The issue here is that the statute does require a surety bond with the application. However, there is a regulation stating that the surety bond can be provided later. And it's within 30 days of, I think, the application being granted. So if the commission would like to have language like that, I'm fine with adding it, but I'd prefer to modify it so that it tracks the language of the regulation a little bit more.
Right, because there's no end date on this. This is more prior to racing, but if racing isn't have a set start date, that could go way past 30 days.
Exactly.
That
Exactly.
conflicts with the reg.
Yeah, and it's important to recognize what the purpose of the bond is. It's really bonding compliance with the racing rules and payment of taxes and fees associated with live horse racing and simulcasting. It's not a construction bond, although the commission could, require a construction bond later on, which was required on the casino gaming side, by the way. But section 3.0, which is where this comes from and is cited here, it doesn't exactly specify what it's for, but it's more for compliance with Chapter 128A, which they won't be able to do until they're actually racing. So the purpose of the bond itself is somewhat moot during the construction period, even though, as Caitlin points out, the statute does say that no license shall be issued unless the person has submitted a bond. The commission then has clarified that by way of regulation.
And I would just add to that if they're allowed to simulcast before they do live racing, you might want that bond at that point.
So given all of that, Todd and Alex, do we even need that line in at all? It starts with for a new applicant. That's what this is. It's an application for a new license. And we know that it doesn't, the regulations don't really fit well for this in terms of requiring a surety bond when the racetrack isn't even built yet. So I guess I'm suggesting that we don't even need this line added in.
Yeah, I think that's fair, Commissioner. I think what maybe the best approach would be to just reference the regulation that talks about the timing of the submission of the bond and ensure we incorporate what Dr. Lightbound mentioned as well, that really before any wagering related activities or other activities under 128A is when we would need the bond. That's what it's bonded.
Let's play this out. I see this, the license is in that chart, the language, the regulation. No, and the statute says no license shall be issued unless the person applying therefore shall have executed and delivered to the commission a bond payable to the commission in the amount of $125,000 with a surety of sureties approved by the commission conditioned upon the payment of all sums. I know we're going to get into it, but this is where the sports wagering statute will have implications. This license, whether it's conditioned or not, the stakes just went way up because now they have access to a mobile So the idea that we're going to just skip over a surety bond, which it doesn't say, I don't know enough about this, quite frankly, but it doesn't say, it's not tied to the language that you said, Todd, and maybe it's somewhere else. But should there be some kind of a bond given to Alex's point? I mean, up front, at least with respect to the statute, and then the reg does say, you know, I don't know, it says that 30 days of the award of the license, even though it says no license shall be issued. I don't know how we reconcile that reg with the statutory language, but apparently that's our.
Well, that's the question, right, Chair, I was having too, is our reg inconsistent with the statute as is?
Yeah,
I agree, Commissioner O'Brien and Chair.
yeah, I am. I don't see how we can override the statute.
Right.
In which case, I think we require the bond,
All right, that's
period.
what the statute says, so.
I think that is a safe approach. Even though the bond may not do anything, but we can talk more about what the bond has to cover.
Yeah.
And, you know, maybe get into that in a little more detail in the near future. But I would agree with the sentiments and that we just keep it in as is and require the bond.
And it's in accordance with the statute. And why don't we find out what surety bond we ask for to make it meaningful? I think that's the question.
Yeah.
Okay. All right. So now that's public comment, page 5. Flipping over, nothing on page 6. Page 7. That looks like just a nit, but a helpful one. What do you think, commissioners and counselors? That's just inserting the word copies because they don't want to send
We
over
do
their original.
certified copies?
I'm sorry, I lost, where are you?
Page, public comments, page 7.
1.1.10.
Oh, you're in the packet. I see. Okay.
Where
Yeah,
is that?
in the red line version submitted by the first comments.
Yeah, by
From
Counselor
Butters.
Hanley. Counselor Hanley, yeah.
Page 3 of his letter, if that helps, Tom.
Yes, that does help, actually. I'm actually not looking in the packet. I was just looking at his actual letter, so that's
Yeah.
why.
Now we're looking at the
We were
packet.
looking at the red line detachment.
Yeah,
Yeah, so it's page 3 of his,
well, it's the attachment.
If
And
you
it
go
would
into the
be-
red line detachment, it's section 1.10. You get to the yes, no.
It's right above section 2.
And Todd, you're right, it's page 3 of the application.
yep, got it. Thank you.
So I would just say, so if we're gonna put copies, just say certified copies. I don't have a problem not getting the originals, obviously, you're not gonna get them, but.
Yeah, that's fine. I mean, I think that was assumed, but we can clarify that point.
Okay, no controversy on that one, commissioners, certified copies, all set. Page 8, there's a deletion. Oh, I was interested in this. Why did he want to delete?
Yeah,
Is there something, Dr. Lightbound, that you know that we don't know? The deletion is subsection H, description of anticipated number of outlets for fresh, pure drinking water for patrons in grandstand, clubhouse, and other locations. Do we not provide fresh water?
Yeah, at the tracks we have now, they have drinking fountains. So I'm not sure why they want to eliminate that. I don't know if that's, if they're considering when they first open that they might be in a tent or something. I don't know. I don't know the answer to that. I guess if they didn't have drinking fountains, they could certainly provide, water bottles or something along those lines.
But what you're thinking of is for all the forest community coming in, that they typically have access. Is it just, or spectators? Are we also talking
The
about?
patrons as well. Yeah, the patrons in the gaming area, and would have access to a water fountain.
Can you refresh my memory right now when the current licensees come before us every year? Is this part of the, excuse me, the
That
language?
is part of the original application, yes.
Yeah,
I'm not sure why we would take this out.
I thought it was curious. Maybe it's because so many people buy water now. And I say that knowing my father's turning over in his state right now, that we buy water in bottles. But anyway, I like filling mine up, so I think freshwater access is still important. So, all right, and it's important that it's part of the original. So thank you. We'll just keep that in. Then page 9, 2.10 or 2.10. I guess that in this case, I think it's a little nit. I don't think it's so critical, but it looks like Commissioner Skinner that he wanted to combine those two. Maybe it's because those studies are likely to be integrated into one. You'd submit the same study twice.
Yeah, economic impact study is listed in both subsections.
It does say both economic impact, but then feasibility. So
Feasibility, viability can just be added to 2.10. Makes sense to me.
Dr. Lightbound, is that inconsistent with what we've asked for in the past, or is there something we're missing?
Can I ask? I'm sorry, Alex, but before we go into that, so the first one says relating to the project and the other one says performed for the project. So are they supposed to gather up anything relevant in 2.10 and yet submit anything they've done in 2.11?
Commissioner O'Brien and all, if I could just add, and Alex, please correct me if I have this wrong. I don't think this question is on the existing application. This is one that we added here so that the commission could really understand the viability of this project. I think that it's a fair comment here. I don't think it was intentionally broken out in any particular way. Obviously, the main thrust here is that the commission have an understanding of what impact this project is going to have. That's what we're getting at. So I think it is fair to combine these questions and just refine the language to make sure that there is some kind of study performed as to whether the project is feasible, what the economic impact will be, and whether it's ultimately viable. I think that's perhaps what you're most interested in, and we could write it that way.
So did legal come up with these languages? So the relating to and the performed for, that's all our language?
That is our language. I believe we took these out of the RFA2 application, so they're probably identified there too, although I don't want to say that for sure, but I believe that's where these came from.
Okay, because when I look at relating to, it seems to be a broader category than performed for. It seems to almost imply if they know of some other study that maybe they didn't do themselves, but they knew of, are they trying to get more in front of us than just what they did? So as you go through and think about language you want to submit to us, I just throw that out as a question.
Yeah,
And then if there is a distinction, we should make the questions identical.
Right.
Are we good then with those options? Make them identical or combine it in a way that captures Commissioner O'Brien's concern? Okay, are we comfortable moving on or? Okay. Item on page 10 of our packet, it's now item 4.4, it's actually the beginning of section 5. This public comment addresses something that is a difficult road to navigate, but he's concerned about giving out information that he would like to keep protected. Public records law makes that difficult, right? Counselor Todd, why don't you address that? I know you've raised this issue.
Sure, I think it's a really important issue to make sure we're clear on. The public records law, of course, as we all know, sets out a series of exemptions, some of which may be applied here, and we can talk about those momentarily. But there is no specific language in Chapter 128A or 128C, for that matter, that exempts language or information submitted as part of an application for a license, unlike on the gaming and now sports wagering side where such language does exist. It does not exist here. So that means that we need to apply just the straight public records law to all of the information that will come in as part of this application. And as he noted, and as we talked about, there's the privacy exemption to the public records law, which would allow us to withhold and from public dissemination a lot of personal information about individuals who are involved in this application process, but it does not cover a lot of the financial and entity related information that may be associated with this process. He, in the comments, suggested that there be some kind of non-dissemination agreement or something along those lines, but there is no such provision in the law that would allow us to do such a thing. So that is an issue to be confronted here, is how, what information will be required and how, if at all, would it be handled under the public records law?
There is always one practical solution, and it depends on what we want to think about and how our investigations are conducted in the amount of documentation. But the public records law is triggered by custody. And to the extent that we don't have NDA coverage, you can review things through a portal and not take custody. And that's a practice that's done routinely. Lawyers do it all the time so that they don't own documents. Is that a practical solution? Not necessarily, if we have to really comb through things. But this is just something I want to offer.
Well, and also you commented that the new legislation on the sports wagering, it does apply
to information submitted as part
in
of an
support of
application.
that, right? So in theory, they're doing a joint potentially. They're a new horse racing. They'd also be potentially for the sports wagering. How does that play in the statute? Do they get the protections from disclosure that are applicable to the brick and mortar and the sports wagering because they're doing a combined?
Well, I think the answer to that question is no. They're not, I don't really see it as them submitting a combined application. I think they're two separate things. In order to trigger the sports wagering law, they have to first have a license under Chapter 128A, which is what we're talking about now. And we'll get into obviously what the sports wagering law says about this. But I think the simple answer to your question is that they're separate applications. Although that is an interesting thought and worth taking another look at. And I haven't considered that specifically, but I don't believe we could loop that protection in here.
Because this is an initial. I mean, I think we want to be always fair about what we're asking for. So I think I appreciate this. There is no real tool. And it's something that we've encountered in our regular day-to-day, right, Todd? So at this point, I don't think we can't add anything into the application right now on this point. I think Commissioner O'Brien's brought up a really interesting issue, whether they might get almost like retroactive protection or something, Commissioner O'Brien, we're saying they as if there's a they. It's
right. No, it's the
applicant,
entity.
right?
Yeah. No, I just meant if they were doing both, but I mean, Todd's analysis of it, that it's really sequential, that the access to the sports wagering really follows the issuance of racing.
Right. But I like the
Aye.
looking to see if they did get the first part,
Right.
the requirement. Is there anything in the second part that would give them retroactive, some are, protections on what they submitted before? I don't see that, but I think it's an interesting legal question, Commissioner O'Brien, right?
Mhm. Right.
So Todd can look at that, but right now, commissioners, I don't see anything we can do on the application before us on this issue, except to think creatively, with the understanding, we do our work in public and a lot of information comes to us in public. Anything, Commissioner Skinner?
I am curious about your comments relative to holder or custodian of records. Is that term defined in the public records statute at all? And if so, does it allow for this notion of viewing documents via an online portal, right? Not equating to holding the record or taking custody of the record.
Right. It's my understanding that that's a device that would work, but it has its restrictions. It could be for some analysis, but it couldn't be for us to come to us. You know what I mean? It would be just for the analysis of team. But if it has to come before us, there's no mechanism for under the current law. I don't think, right, Todd?
I think that's right. I mean, once you rely on a piece of information in making your decision, then it's part of the record. And whether you looked at it on a portal or otherwise, it's I don't think it's protected. To the chair's point, though, if you needed me, for example, to just confirm that there is some piece of sensitive information in place, and you would accept a yes or no, just to make sure we covered our bases somewhere without knowing exactly what the document says or something like that, then yes, we could probably get there. But I don't think that's going to answer the question completely here. I don't think we can show you for example, their feasibility report. I don't think we could just say, hey, everybody just go log in and read their feasibility report to see what it says, because you're going to rely on that.
That's right. I didn't think so. That's why I wanted to just kind of dig into that a little bit. Yeah.
Not for us.
Yeah.
Not for us. Just for the kind of due diligence he said.
The other exemption that comes into mind is the investigatory exemption. And that's one I've heard mentioned in the past in this context. The important thing to understand about that is that it only applies as long as the matter is being investigated and would somehow compromise our ability to complete our investigation. So it's of limited effect, and it may cover certain documents for some period of time, but ultimately not completely in the fashion that I would think the applicant would be seeking. So that's not really a great solution here either. There really are no tremendous answers to this, which is why it's built into the gaming law and the sports wagering law that certain information is absolutely out, because there is no exemption otherwise.
Yeah, and certainly I didn't want to in any way indicate it's what I suggest is to circumvent the public records law. It is simply a way to sometimes be able to look, but not rely on, it's really very, very difficult when it's just no exemption on the public records law to get around this as Councilor Hanley suggests. That requires, I think, a legislative fix.
Madam Chair. Councilor, do the current licensees have to provide very similar information under the same rules and no protection, for a lack of a better term, currently?
If you're referring to Plain Ridge Park, so Plain Ridge Park is at present the only racing licensee. And we do not ask for this exact information as part of their renewal application, in that they're already up and running. So for example, you don't need a feasibility study as to how all that's going to work and things along those lines. So, and we have not historically conducted suitability of the racing entity specifically. Obviously, we conduct suitability reviews of most of those folks under the gaming laws, for which we do have protections. But if I understand your question correctly, we don't receive this type of information from Plain Ridge Park when they seek to renew their application annually.
And I just want to clarify, I think Pat Hanley's comment is directed to qualifiers, section 5, qualifiers and suitability, as opposed to like the feasibility.
I think that is, yes, absolutely where he directed, but I think it is important just for us all to recognize that it has, of course, broader implications than just this one section, although that is where he kind of identified or focused his comments.
And so I just want to follow up with Commissioner Maynard's point, and other commissioners, let's think about this when we get our suitability information. Much of it can be public, but to Todd's earlier point, it's exempt under, a lot of it's exempt under the privacy exemption under public records law. With respect to the entities that are assessed, a lot of it's protected under the NDA that's permissible under 23K. If PPC's horse racing track was not attached to a category 2 licensee under 23K, that protection wouldn't follow. It's because of the fact that it falls under under the category 2 license. That's how the NDA follows.
That's right.
And also my follow-up question that I heard, we're going to be asking for more suitability review under the new applicant than what we ask of the current renewal? Outside of those under 23K? Or are we going to be, is that going to be an update to the renewal license?
Well, I think that is the question, at least part of the question before you is what level of suitability do you want to conduct? There are obviously practical differences between PPC, an existing entity that you're familiar with and whose principals have gone through a thorough suitability review and background check, and then some new entity that we don't even know who comes before us, and individuals who we may never have encountered before, who you're going to want to ensure are suitable to hold a license. So it is possible that the initial suitability review anyway will be more rigorous in this instance than it is for the renewal of the PPC license.
Maybe when we go through the license provisions itself, that will be helpful to Commissioner Maynard. So if we, at the very least on that point where he's asking for some kind of relief from disseminating that sensitive information, the answer is we really don't have a tool right now. Is that fair?
Okay. I think that's right.
Yeah, and so I think the last comment that I'm seeing really relates to Commissioner O'Brien's earlier, more global question, is the impact of the sports wagering statute now, because if I understand correctly, Section 8 may be somewhat implicated by that statute. So should we, before we go on through the license itself, should helpful for Todd, Commissioner O'Brien, to update us on what we view as the implications of the new law on this globally, and then is that the right approach, Commissioner? Okay, Commissioner Hill, you're good with that?
I am. This is like one of the biggest issues that I've red flagged, as you already know. So yes.
Okay, so we got through, I think, comments submitted at least by this particular public commentator. Let's move. We'll table the rest because even though I'm going out of order, it's what I said earlier, just because I think it's really pertinent, and then we'll go back to the other public comments. Some of them are critical policy questions. Okay, so why don't you give us that update, Todd?
Sure. Hold on one second. Just need to close out some documents here before I share my screen. Okay.
Excuse me.
There's, with your indulgence, I'll just share this document with you. So we're looking at the same thing. This is, hold on a sec. So this is what was the sports wagering bill. It's now obviously codified in the law, but it's the same language. So I think we can just take a look at this. There are two things that I'd like to just bring to your attention. One gets specifically into race days and simulcasting, and the other is kind of the broader question as to how this affects or what effect being awarded a license under Chapter 128A will have. So there are a couple of places to draw your attention to. The first is right here, as you'll see the term, and I assume you can all see my screen here. The term Category 2 license is defined, and you'll, of course, are well aware that there's 3 categories of licenses that have been established under the sports wagering law. The racing piece of it falls under Category 2. So I'll just talk about Category 2 if that's okay. And Category 2 itself covers a fairly wide swath, but the part that we should really be focused on for purposes of this conversation is the highlighted language that talks about that it's a license issued by the commission that permits the operation of sports wagering in person on the premises where either live horse racing is conducted in accordance with Chapter 128A or the other entities. So this is an important starting point. The next part, though, and it's directly related. So let me just go over to the next relevant piece, which is right here. So this is the licensing section of the sports wagering law. I don't have the, it's section 6, B2 of Chapter 23N. And it says, the commission shall issue a Category 2 license. And of course, we just looked at the definition of the Category 2 license, which includes to an entity that was licensed under Chapter 128A to conduct races. The commission shall issue a Category 2 license to any holder of a license to conduct a live horse racing meeting in accordance with Chapter 128A. And just to kind of give you a full picture, it's not that they automatically get a license. It's any entity that meets that also meets the requirements of Chapter 23N and the rules and regulations of the commission. So they have to, of course, meet other rules that we'll put into place and regulations. But as a general matter, if they do so, an entity that holds a license under Chapter 128A is eligible, let's say, for a Category 2 sports wagering license. And that's what the new sports wagering law says. Now, just to add full context to this conversation, little 2, and in fact, the other piece of the definition we just looked at, these get into the 2 simulcasting, the existing simulcasting entities. So a running horse racing licensee, here, this is referring to the Suffolk Downs license. And little 3, the Greyhound meeting licensee, this is referring to the Raynham Park license. So they're all kind of grouped into the same section of the statute. And they all are, it says the commission shall issue them a category 2 license if they meet the requirements of the chapter. But to everyone's point, what we're doing today and the review of this new racing application is critical and supremely meaningful in that if an entity submits this application we're talking about and is awarded a license under Chapter 128A, it will make them eligible, let's say, for a category 2 license. And that is important to understand. So it carries with it more than just the ability to conduct live horse racing and simulcasting and potentially ADW operations. It also carries with it the real possibility that they will be allowed to conduct sports wagering operations as well. There is one other, let me pause there for a second, and then I wanted to get into the other piece of the sports wagering bill that is relevant here. But are there any questions or otherwise about just the eligibility and the category 2 license?
I understand what you just read to us. I'm trying to understand how that coordinates with the new application and the concerns that were brought up. So would we take away 8.2 because this overrides that?
Well, Commissioner Hill, let me actually, it might be helpful if I just move into the last piece and then I think that might answer your question.
Thank you.
Can we just look at this language just for one second as a pause? Commissioners, it's any holder of a license. There's no cap on this particular type of license, correct, Todd?
That's right. And by the way, Madam Chair, that is true of Chapter 128A too. So at least in my opinion, there's no limit on the number of what are referred to as running horse racing meeting licensees or thoroughbred racing meeting licensees. You could.
A live horse racing meeting here. All right, so do you want to go to the simulcast language?
Yeah, if I may, let me just scroll further down. Now, this piece amends, this is in the sports wagering law, or Sports Wagering Act, I should say, but it actually amends Chapter 128C and is not, let's say, directly related to sports wagering. It's line 927 here. There we go. So this is Section 6 of the Sports Wagering Act. And as you can see, as I just said, it amends Chapter 128C of the general laws. It's not going into Chapter 23N. And it's important to kind of take a look at the introductory language here. So 128C at present, well, I shouldn't say at present because this is not the law, but before this was passed, had 8 sections. It now has 9 sections. So this adds the 9th section to Chapter 128C. And it starts by saying, importantly, notwithstanding sections 1 to 8 inclusive, meaning that regardless of what any of those sections presently say, what this says is going to control this particular issue. And this is important because it does kind of override some language that's in Chapter 128C. The part of the section here that I haven't highlighted talks about offering wagers for Greyhound racing, which is also important to understand, but it's not really relevant to the present conversation. That's why I didn't highlight it. But we should talk about that at some point too. But the part that is relevant is this highlighted language here. And it says that in a running horse racing meeting licensee shall, and I'll finish that of course, but I wanted to pause for a second there just to note that what we're about to talk about only applies to running horse racing meeting licensees, which is thoroughbreds. It does not affect Plainridge Park Casino because they are standard breds. So that's not addressed here. So any running horse racing meeting licensee shall conduct not less than 20 live racing days at a thoroughbred horse racing track, provided the commission may waive this requirement as necessary and appropriate to ensure the financial ability of the licensee to develop and operate a racetrack. So the question is, what does this mean? Read in a vacuum, it's hard to understand what it means, but you'd have to take a look at Chapter 128C. And let me show you, I can show you 128C. I'm sorry to bounce around here. So you can see kind of what piece of the statute it's really getting at. If you'll bear with me for 1 second. There it is. Okay. So I will share this with you too. Okay. So this is Chapter 128C, Section 2, dealing with simulcast wagering. I should point out, just to clarify, 128C in its entirety talks about simulcast wagering, as opposed to 128A, which talks about live horse racing, pari-mutuel wagering, and things along those lines. 128C is focused solely, I think, on simulcasting. So it talks a lot in here about the signals that the different licensees are allowed to carry, and that's important to understand too, and we could go through that, but the relevant portion comes in down here. And it says that no racing meeting licensee shall simulcast live races in any racing season unless the racing meeting licensee is licensed to and actually conducts at least 900 live races over the course of not less than 100 calendar days during that racing season, with no fewer than 7 races completed on any of those 100 calendar days. So this is the existing law. The way it has historically been viewed, and the way I read it, is to say that essentially, in order to qualify to conduct simulcasting, which attaches, by the way, to the fact that you have a license under 128A, you have to race for 100 days. You have to have a racing meeting of 100 days, which is not an issue for Plainridge Park. They race over 100 days. You may recall in the past, was it 2 years ago, Alex, or last year, where because of the pandemic, they fell underneath. And there is language in here that the commission looked to that allowed you to authorize them to continue to simulcast, even though they fell under 100 days. And here, that's right here. It says, except if the commission determines that a licensee cannot conduct a full schedule of live racing performances due to weather conditions, racetrack conditions, strikes, work stoppages, sickness, or quarantine not within the control of the licensee, the commission may permit the licensee to continue simulcasting, etc. That's not the territory we're in now, because the baseline rule is that you have to race for 100 calendar days. Okay. So I realize I'm moving kind of quickly here. So let me just stop there for a second before I go any further.
And that's annually.
Annually, yes. So let's back up a step. When you review Plainridge Park's application to conduct racing annually, one of the things they submit, and that's required under the statute, and we'll talk about it in the context of this new application too, is that they submit the whole schedule, their whole calendar, which has to include at least 100 racing days if they want to simulcast. And of course they do. Simulcasting is a critical component to any viable racing operation. And it's this part of the statute that triggers their ability to be able to simulcast. And we have not had an issue with them that I'm aware of. in which they have fallen below the 100 days, except during the pandemic. So that's why you've perhaps never had an opportunity to review this section of the law or encountered any issues with it, because they've never come in under that. With a new racetrack, though, it has been suggested, and I think most would agree with the idea, that conducting 100 live racing days at a new thoroughbred racetrack will be difficult, just for a number of reasons, not the least of which is the fact that there aren't enough thoroughbred horses that would be available to race over the course of 100 race days. And I think it seems to me that most would agree with that principle. And so at least for the first, let's say, year or two of any thoroughbred racing meeting, it seems, from what I understand, unlikely that there would be 100 races. Maybe eventually you get to that point, but in the short term, let's say it's unlikely. And it's important to understand that, because that's why the language, I believe, was included in the Sports Wagering Act that talks about 20 live race days. It says, notwithstanding anything that's in 128C. So it basically means, regardless of the fact that section 2 that we're looking at says 100 race days. And let me pull this down for a second. We can go back to the other document. Notwithstanding 128C, they're saying the licensee, the horse racing meeting licensee shall conduct not less than 20 live racing days. And we can stop there for a second, because then there's additional language built in that appears to address a new racetrack that's being constructed. But my read of this language in the Sports Wagering Act, which is now 128C section 9, is that this 20 live racing day reference is intended to supplant, on the thoroughbred side, the 100-day requirement and bring it to 20 days. Bless you.
Sorry, my apologies.
No. So let me stop there for a second, because this is complex, but super important. It's important to make sure we're on the same page with this. And so this is what Mr. Hanley was commenting on in the draft, and he's absolutely right. When the draft was initially put together, this Sports Wagering Act language didn't exist. So that's why it's not referenced in there. We would absolutely have to include it in there, but it's important that the commission take a position as to what this means. And I've obviously shared my opinion with you as to what it means. But if we're going to put it into the application, it's important that there be some type of agreement that that's what we're going to do with it.
Commissioners?
I would add one wrinkle, Todd, which is that this provision doesn't go into effect for a year.
Yeah,
So,
thank you. Yep.
for if an application was for next year, it wouldn't apply. But if an application was for 2024, it would apply.
And that is at the very end, the effective dates. That applies to this section and another section, correct? That
Yeah.
one?
So this is the Sports Wagering Act, and it says sections 2 and 6, and we were just looking at section 6, which will take effect 1 year after the effective date of this act. So thank you, Caitlin. That's absolutely.
And you're still interpreting that 20 days to be 20 days annually, correct?
That's right. So the only other thing that to just take a quick.
Can we just, Caitlin's point is a really important point. As we think about the license, like Commissioner Hill's original question, like how does this alter the application? So they don't want us, they say that we could waive this requirement as necessary and appropriate to ensure the financial ability of the licensee to develop and operate a racetrack, but we couldn't do that for another year.
For a year. And the way effectively, I think what that means is that if you were to award a license under chapter 128A, you know, in the next month or three or what have you, they couldn't, the licensee couldn't then turn around and come in within the next year and say, oh, by the way, please give me a license to simulcast too, because I need it to ensure that we can develop and operate this racetrack in the future. The request can't come for at least a year.
How about the 100 days?
So the 100 days piece too will be in effect for a year from whenever, a week or so ago, which is okay. It doesn't really affect this application process because they're not going to be simulcasting anyway. So even if they come in and say, hey, we're only proposing these 20 race days, you could still give them a license. The law doesn't say that you can't have a license to race for under 100 days. It just says you can't simulcast if you don't race for at least 100 days. So the fact that this piece of the law doesn't kick in for a year will not impact that at all, because they wouldn't be racing anyway.
Well,
Let me take that down for a second.
okay.
Okay, now, oh, sorry, go ahead. Someone was saying something.
I was just going to say, ask questions for Todd, and then also, I'm hesitant to go backwards in the application, but I think it's important to connect this right to, I just lost Commissioner Hill, but right to section 8 as Commissioner Hill was suggesting. So if we look at the applicable provisions, it's actually section 8 and 9, right? Section 9 is what I thought.
I think it's mostly, if you're referring to section 8 of the application, right?
Yeah, because Commissioner Hill referenced section 8, but that's facilities and equipment on my document. Do you mean to be referencing section 9? And it's exhibit, I think just one note, all the exhibit numbers are just off by one number. Just sort of.
I am looking at draft page 13, 8.2.
Yeah. See, I think, oh, I'm looking at page 13, 9.2.
That's part of your packet, right?
Yeah.
I'm looking at the draft that they sent us 2 days ago. Or
Well, I hope we're all looking at the same document.
says in accordance with GL chapter 128C, section 2,
Right.
no racing meeting. That what
Right.
yours says?
Yeah, I think, hold on. The problem, I'm sorry, I realized this after I put this in the packet. The reason it's actually section 8, but in the draft it says section 9 because somehow, if you look back at section 3 and 4, you'll see that there's a highlighted piece in the packet for section 4. That's actually a question under section 3. So all of the sections got pushed back a section. There's actually only 8 sections in the application. I don't know if that makes any sense, but if you look at.
So I'm recognizing that the packet that the public has in front of them is not aligned with necessarily the document that, and that is just a note. So it sounds like we're just one off. One thing I noted was on the exhibit numbers, they're kind of just one off. That's okay. But so when I'm looking on page 13, it's your 8.2, and that makes sense, Brad, because that's what you referenced was 8, which I knew what you meant, you know, but it just happens to be 9 and 9. Okay, so section 8 on page 12, wagering and simulcasting. Okay. In terms of what you just went through, do you want to walk us through that section in terms of what you would recommend for changes, or do you have that?
Sure. Yeah, I think that if all are in agreement, so we would we wouldn't necessarily want to delete, well, let me start over. It's important to remember this application applies to both thoroughbred racing and standardbred racing, even though as a practical matter, we've heard that there's mostly interest in developing a thoroughbred racetrack, not another standardbred racetrack, but the application itself was designed to cover both. So for that reason, I would not recommend that we pull out the existing language in 8 or 9.2 altogether, but supplement it with the new language that's now in chapter 128C, section 9, that talks about the 20 days instead of the 100. And we would ask a question, we would tailor the question that's a little, to focus it a little more on, if you're a thoroughbred applicant, are you going to have at least 20 race days? If you're a standardbred applicant, will you have at least 100 race days? And so I would definitely suggest that we do need to include the new language in here.
Commissioner Maynard, you're leaning in.
But Counselor, what I heard earlier from Caleb was that we're a year before the commission could actually adopt that language out of the sports wagering bill. So why would we put in that provision now?
Well, it's a great question. I would say that we know it's the law, right? We just know it's not taking effect for a year. And I suppose the law could be amended, but it's not some remote or speculative thing that might happen. It has happened. We know when it will be. And as I mentioned, assuming the law stays in place, and I suppose anything is subject to change, but assuming it stays as is, if you were to award a license to race under Chapter 128A, and the applicant only proposes 20 racing days, we know what the governing simulcasting law is going to look like. And that's really what we want to address here, I think, because that is what they're going to want to do. And it will be okay. I don't think you want to not include it and say, okay, well, since this doesn't kick in for a year, you're not going to be allowed to simulcast, because that's not necessarily true.
Can we address Commissioner Maynard's point though by somehow showing the trigger date or something, when that actually could take effect? To avoid confusion?
Yep, I think that it is important to include the fact that this language doesn't kick in for a year. But I think it will be important that the commission notes that the race days are something less than 100 days, and that assuming this provision of the law stays in effect, that they would qualify to simulcast.
Do we know that can I ask, I may have just maybe asking a question I shouldn't know the answer to. We know that it's less than 20 days, or is that only connected with simulcasting?
Well, it's in Chapter 128C. So the way I've always read it is that it just applies strictly to simulcast.
That's correct. It applies to the ability to simulcast, and it's not financially viable for a racetrack to not have simulcasting. And it's not financially viable to have live racing.
From our racing director. I mean, that's what that I think we're hearing you say that based on your experience, right, Dr. Lightbound? But it's not required by statute to have simulcasting.
Oh, no,
Right.
It's not required.
Yeah. So if they didn't have simulcasting, would they have to do 100 days? Like under 128A? Is there any, there's no. there's nothing. It's only about simulcast. That's what I thought. Okay.
Exactly.
And I understand what you're saying. They're linked, and that's why the days came into the equation.
For me, Todd, the question around the timing of the application of the law, the changes to 128C Section 2, relate to the legal question that we talked about at a couple of earlier meetings around whether the commission can grant a license for a future racing season or date. And if the answer to that question is yes, why couldn't we consider an application for a new track that won't be up and running for at least another year under the newly worded statute?
You can, and maybe I probably didn't explain it artfully enough, but the way you explained it is better. So yes, you can. That is the point.
Well, so then that would get to Commissioner Maynard's question around the, whether or not we'd want to include that language in this application, even though it doesn't go into effect until a year from now. Right?
Yeah, that's very helpful. I still think having in there some sort of effective date or explaining that this is a wrinkle in the application may be important. But yeah, that definitely does clarify some of it.
And that assumes that we as a commission determine that the interpretation of the statute allows us to do greater than just the next calendar year. Because if we decide no, then that language doesn't go in for another year.
Exactly.
And Commissioner Skinner is touching on the issue that I raised about our ability to our ability to issue a license in the future and attach conditions. That's where I would like to have the legal analysis memorialized in writing so that we can go back to it each time we kind of come across these issues. All right. So should we now, I'm looking at time, it's 12:22. My thought for we should probably, before we close off, I wonder if we should go back to the public comments that we have and at least chew on them a little bit. I'm not sure if we'll resolve them, but then maybe take a break and then just walk our way through the license itself. And any particular questions we have, or do you want to keep on working through? We do have a hard stop, I think, at 2. Should we just turn back to the public comments first? And while you're thinking about that, I was thinking 12:23. I mean, maybe it'll get through these by 12:30. The first one is in public comment packet. Public comments, page 24 in our packet. This is from the New England United for Justice. It appears to be a nonprofit organization that is really referencing a policy that was in place during the construction of the casinos. 311 labor harmony.
And Madam Chair, not to interrupt, but we basically got 2 comments on the same point, so
We did, yeah.
probably take them at the same time.
Yeah, I think it was MBTU, Massachusetts Building Trades Union on page 31. So, Todd, do you want to just set us up in terms of the history on this, because it is rich in history? And I don't know if Crystal's involved. She's here, so if Crystal has any insight. She was quite closely involved in this back in the day.
Yeah, so let me just quickly pull up the section here so you know where they're coming from. Okay. All right, so this is chapter 23K, obviously the gaming law. And in section 18, which I hope you can see here, it talked about a number of objectives to be advanced in determining how to grant the license, i.e., what things should the commission think about when deciding who to give the licenses to. And there are 18 different things. These were all, by the way, incorporated into the RFA2 application. That's how they were manifested. And there were obviously a lot of other things included in the RFA2 application. This language does not exist in chapter 128A or C, but 128A does give the commission broad discretion and flexibility to basically ask whatever you want and whatever is relevant. So this is not mandatory, but this is certainly within your discretion to include. And so this is, again, in section 18 of chapter 23K, and they are talking here about section 18. And I can maybe just give you a moment to read it. I don't know if you can all see that, okay?
If an applicant is looking for sports wagering opportunities through a mobile app, there is a, am I correct, commissioners, that the $7.5 million capital investment applies, which is there's a proposal of a track and amenities is relatively low, but there is at least a minimum of $7.5 million capital investment that applies to this particular license as well.
Madam Chair, I read it as a category 2 licensee shall make a capital investment of not less than $7.5 million within 3 years after receiving a sports wagering license. So I would say it doesn't.
So
In my reader.
yes, so they'd have to get the 128A license, and then that would allow them, if they comply with the 23N rules and regulations, the sports, and then they have to do the 7. So there is, the construction is presumed. So this is relevant. I just wanted to mention why this is relevant here. So commissioners, what's your thoughts on this? Do we want to include, do we want to think about this? Do we want to include this?
I like this language. I mean, one of the things I was most impressed with when I came on in 2018 was the success of that program that went with the construction phase. And I'm happy to hear, obviously, other people's comments or the industry's comments on it, but I really thought it was one of the most positive things we did as a commission in terms of the casinos.
And Crystal was very involved in that. I want to note that. So she's familiar with the implications and the communities that were involved in really standing up this. Before we move on to more general, can I ask the technical question? Would we include that language? The Ms. Ramos looks as though she's suggesting this 3-1-1 labor harmony. Is that?
I think I was trying to, and I was going to ask a question of Todd myself, because I think what she's referring to in this is the old application, but I was down to find it. The actual language in the RFA2 is a little bit closer to what is included on page 51 of the packet with the building trades union.
Okay.
That's section 6, public interest.
Which 31, right?
Basically what Todd was just showing us. Yeah. But so the interesting really the difference there is the labor harmony piece more closely refers to the PLA agreements, which are the union agreements that they would negotiate or have in place prior to compiling the application. And I did see on page 34 of your packet where there's a section 6 public interest. 6.5 essentially shows the some of this work already, the plan to attract and employ a diverse workforce in both construction and operational phases of the proposal. So it could just be if you are interested in knowing whether there are any PLA agreements or what they're referring to here as labor harmony, you could build that into that component, I think.
So the language, I appreciate you're flipping us over to 32 because that does track the language of the statute, section 18, right, Todd? Pretty, if not exactly closely, right? And does,
Labor harmony question, yeah.
and then so section 4 refers to this assuring labor harmony. And then, Crystal, did everybody enter into these project labor agreements for the casino developments? Is that familiar terms?
The application portion of the RFA2 predates me, but I do recall from our AOC meetings, several discussions of these PLAs. I wouldn't want to go on the record saying it was every one of them, but I'm almost certain it was every one of them. We did track, of course, on even from Plain Ridge on. So those access and opportunity, sorry for newer commissioners, the access and opportunity committee meetings were how we tracked and managed the workforce and the union agreements across the board as they were developing the construction on the casinos. And all of the unions were involved in those meetings as well. So I think there was a question at one point whether a PLA was in place prior, but I think they were in place, if not prior, soon after.
So
Of
Todd,
course.
would we want to add, or would that be like a, I want to turn to the other commissioners. I'm just thinking technical. So that technical question, what do we feel? Commissioner O'Brien, I agree with the sentiments you expressed perfectly. Commissioner Skinner, Commissioner Hill, Commissioner Maynard, how are you feeling about adding this dimension?
I would have no problem with it.
I support adding it. I would even venture to say that we should be thinking more broadly. One of the comments that we received had to do with community transparency and, holding the applicants accountable for whatever promises they might make to the community, in furtherance of a license from the Gaming Commission. So, just asking us all to think about not only adding this labor harmony language into the application, but something that relates more broadly to hold applicants, again, accountable for the commitments that they have made to the region.
Good, so that could be either here or maybe even in where there's the local approval provision. I'm not sure where we make it in a separate section. I like that, Commissioner Skinner. So Commissioner Maynard, how do you feel about adding the?
I support adding the language. Also, I do to Commissioner Skinner's point, and I'm looking through the application again. I'm thinking about other ways that we can take into account different factors, including some of the diversity standards too. So, but I'm definitely thinking this language is good language.
So just to be clear, would we have a new section, Commissioner Skinner, or would we try and add it to what I'm looking at is 6.5, which is page 10 of the draft?
Section 6 is entitled Public Interest, so I think it would make sense to add that right under there. Todd, do you agree?
Yeah,
Caitlin?
absolutely. I had it penciled in as 6.6, and basically include a question similar to the one that was on the RFA2 about the labor harmony. And that's I think what I'm hearing. And the only
Well,
thing I
maybe
would,
6.7 could be a more general statement to Commissioner Skinner's more general upholding of, promises made to the community.
so not to,
Go
I-
beyond construction is what I think you're getting at, Commissioner Skinner.
I had that penciled in up above where we ask about local approval, if you're
Yeah.
inclined to
Yeah.
ask for any promises or what have you.
That's
But
what
I mean,
I was
That's
saying.
section,
local-
Todd.
that's section 4.
That was my earlier suggestion, but I wonder if it's maybe more, local approval might be more technical in terms of getting permitting approval, where I thought Commissioner Skinner might be getting it more. If you're making promises, you got to be transparent and stay and committed to them. But I don't want to put words in your mouth, Commissioner
Nope,
Skinner.
that's exactly right, Madam Chair.
I thought approvals first too, local approvals, Todd, but then I could be convinced of making it more on the public interest. I like that though a lot, Commissioner Skinner. We do need to go through local approvals in more depth or as we go through the license. So I think what we've just done though is we've reached a consensus in terms of we'd like to see language addressing at least the construction. And I assume that we're very familiar with having our licensees report to us, and they did report on the construction repeatedly. So we would want that, the licensees to be held accountable, right? Commissioners, then that would be in there. I think that was the magic, right? Crystal was the continuously.
They were required to report to the commission quarterly, but they did meet and report monthly when we were doing the access and opportunity committee to continue tracking as we.
Very, that accountability, it was not it turned out to be a team effort.
It was a large, yes, and just across the state and several different key players, but it was a large undertaking, but in the end, everybody was on the same page. So I think it could certainly be remodeled, like modeled right after that same system. I will send you further information that I have for you on those PLA agreements as well.
Okay, are we good then to turn to the next comment on page 25 of our packet? This is from Mr. Umbrello, who's the executive director of the New England Horsemen's Benevolence and Protective Association. We hear from Mr. Umbrello frequently, and he's a collaborator and helps us on our horse racing policy development. We
And he's on
appreciate
the
your
call.
input. We appreciate your input, Mr. Umbrello. So these 2 points are highlighted on my document. I don't know if they're highlighted on anyone's, but for section 5, 5.9, and then again 8.2, which we are now reframing. 5.9, do you want to go through that, Todd?
Sure. Let me just find his comment.
I think what it is, and I thought it was fair, is that he thought that the question should be broken out perhaps for clarity on 5.9. Am I right, Caitlin, on that?
I think that's right, yes.
They're written seriatim with just one yes or no right now, I think, and his suggestion was break them out by category to make it a little clearer where the potential issue may lie.
I think that's a helpful recommendation.
Yeah.
And then on his next, are we all set with that one?
Yep.
Okay. And then the next on 8.2, he points out needs further discussion and concern around the language pertaining to race days and races. And I think our discussion on that probably addresses this concern at this stage anyway. Agreed?
Mm-hmm.
Okay. So thank you, Mr. Umbrella. We always appreciate hearing from you. And your recommendations.
The only thing I think he puts in more specificity, Kathy, and I think we just remember to add it to our discussion, maybe in one of the notes when you guys are redlining, is his last paragraph,
The person.
the purses, and whether that plays into looking at, you know,
Good point.
whether that is a substitute.
Alex, do you have any suggestions on that one?
Alex, I'm sorry, Madam Chair, before Alex answers that, just looking for a little context for those of us who aren't familiar with
I guess
the
that's why.
purse agreements.
That's why I turned to our expert. Alex, this is on page 26. It's from Mr. Umbrella, and I'm sorry that I didn't, thank you, Commissioner O'Brien, for raising it, because I did note it last, nights ago. We suggest that as long as a purse agreement has been signed by any HBPA and racing licensee agreeing to the number of race days and purse structure, then there should be no restriction on race days and races pertaining to this application. Can you help on this for background and maybe how we might remedy this, first starting with Dr. Lightfoot?
So yeah, usually in our original application, it does ask about a purse agreement. Sometimes the tracks and the horsemen have not had a purse agreement in place when they have applied, and as long as they were working towards one, they have gone ahead and been given their license. There's even been time, and Todd and I were talking about this yesterday. I'd have to go back and look what the language says about the purse agreement, whether it needs to be signed by the time of the application or by the end of that calendar year. I know there have been calendar years when the purse agreement wasn't signed by the end of the calendar year. And as long as, legal counsel was involved and as long as the two sides agreed that they were working together in good faith, they were, allowed to keep negotiating until they did get the purse agreement and they didn't pull the simulcast signal. Talking about the number of race days, that's really, like you all were just discussing, that's been put into the sports wagering bill now. So they're, that's taken care of in that section with the 20 days and the discretion that's given to the commission.
So by restriction, where it says there should be no restriction on race days and races pertaining to the application if there's a purse agreement signed, is he referring to the licensing limitations, the conditions that are precedent to issuance of a license relative to the race days?
I think this was sent before the sports wagering bill came out that specifies the 20 days now. And so at the time, he was suggesting that if the horseman and the future track agreed to a certain number of days, that the commission should, basically go along with that. There shouldn't be a restriction on the number of days in races.
Meaning there shouldn't be a requirement to race a number of days.
Right.
Okay.
But that's
wondering
included now, and that's been addressed in the sports bill, in the sports betting bill.
Yeah, so Nikisha, I was also thinking, do we take that comment and more, is that something we can take into consideration? I wasn't totally comfortable with them coming to an agreement and that being a substitute for statutory minimums, but more that that's something we as a commission decide that we take into consideration. Maybe we set a minimum days based on that agreement. Like we could, and I was taking it more as along those lines. So even though it went from 100 to 20 potentially now, I still think we could say, fine, you've agreed to 15, but we are going to make that a condition because you guys have agreed to it.
Understood. But I think in order for that to happen, we'd have to identify we'd have to relate it to the financial stability of the
Right.
the
Right.
applicant, right? Okay. Got it. Thank you.
Okay, looking at the other comments, I think we have a few that were submitted really in connection with a particular potential applicant that really I don't think are as relevant for our review today on the license, but I might be wrong. Commissioners, what do you think? Then we have Ms. Kellogg's that were submitted on page 35 and through 37, and they might be helpful for us to look at as we go through the application, unless somebody thinks otherwise. We heard her public comments, and she was kind enough to reduce them to writing, and I thought that might be a good way for us to do a side-by-side with hers as we go through. But in terms of the comments from Plymouth, do we need to go through those now? Is there anything that am I making too much of a general statement to say that they're not pertinent today for our exercise?
I don't think they're pertinent to what we're discussing today
Right.
at all, actually. I appreciate their comments and
Yeah.
welcome them for sure, but I'm not sure that it addresses anything to do with a application proposal that's before us.
I do think they make us think about the local approval process, and they are.
For sure.
Commissioner O'Brien is shaking her head, so.
Right, but not the question on the form that we're talking about today.
Okay, thank
How
you.
we assess the answer is a different thing, I think, than what the agenda is today in terms of what's going to be in the actual application.
Agreed.
And to that, yeah, so for that, I think I appreciate Commissioner Hill saying we really appreciated it because it does focus on the overall process of local approval. Commissioner Maynard, Commissioner Skinner, how do you feel about that?
I agree.
Great.
Okay, so is this a good time to take a break? And then we'll go through the license itself with any particular questions that we have. If we run out of time, we'll just have to address that. But I think we have a hard stop at 2. It's now 10:01. What break do we need? I know some of us are in this, in the office, a little bit harder to get some lunch. A full half hour, is that going to be enough? 30 minutes?
If we're going straight to 2, Madam Chair, I would like the full half hour. If that's okay with everyone
Yeah.
else.
I think
No,
we need it.
Like the
I
right way
think we
to
need
go.
it. And just a reminder to those who are participating by phone or listening today, we did have an earlier meeting that started at 9:30, and we had a 10-minute break. So this is earned, certainly. All right, then it's 12:48. We'll do a 1:20, and I'll have a good review of the application for the stage, and plan on a break, finishing up at 2. All right, thanks, everybody. Very, very helpful to me, at least. Thank you.
So we're gonna stay on the meeting and then,
We'll stay on the meeting, but convened at 1:20, and so I think Dave will put up his form.
perfect.
Thank you.
You. Bye-bye.
Just mute. Thanks, Dave.
We get to take it down?
Yeah, all set. Thank you. Thank you very much. Give me a minute to get my papers in order. Okay. Thanks, everyone. Caitlin, it was fun to see your little one earlier.
Oh, thanks. I think that was her first public meeting.
Our grandson turned 1.
Congratulations.
Yeah, on the 14th. And when he has his picture taken, he points. So it looked like he was saying, I'm 1. It was very, very good, a keeper for a picture. All right.
A framer, as we call it.
Oh, it's a framer, yeah. So we can get started with our business at hand, but I want to take a roll call because we're using the virtual platform. Back to Commissioner O'Brien.
I am here.
Thank you. Commissioner Hill.
Live and in color, Madam Chair.
Great, thank you. Commissioner Skinner
I'm here.
and Commissioner Maynard.
I'm here.
Great, thank you. And thank you, Executive Director Rouse, Dr. Lightbound, and our legal team today, Todd Grossman, Caitlin Monahan, and those of you who are joining. I know Judy is in the background. We appreciate your input here as we make our way through this application for a license to hold or conduct a racing meeting. We've gone through the public comments. I did want to keep an eye on Attorney Kellogg's comments as we go through. Unless you have a different approach, I thought we'd just start at the beginning. And if we're good, we're good, and we'll continue on. But if we have any questions for either Todd or to discuss among ourselves, we'll stop and take some time on each section. But I'm starting, I think, unfortunately, my printout is maybe a different version, but I am using the public packet one. And if I get off, I'll probably refer to just the section in terms of the background. Hopefully I'm not confusing things. So starting on page 2, all the background information, we had a little bit of input earlier. Anything that we need to address that came up for you? That's section 1. Hearing nothing? I'll give everybody a chance just in case. Okay, and then the bolded language actually applies to sections 2 through 5. Todd, correct me if I get the numbers wrong, right? Okay.
Yep.
Any questions on, let's just do section 2 first. And this is project summary and financing. I'll make one observation, the italicized language, where the first time it comes up is under 2.10 2, I believe. It says, please note the commission may condition any license award on applicant completely and satisfactorily answering this question. I've already noted that that's where I do think memorializing the legal analysis for that statement will be really helpful. You know, what and our ability to condition. I think this gets to some of Attorney Kellogg's comments initially. Anything else? Anybody have on section 2? I have one little note, and this is for Dr. Lightbound. I think I saw it in a comment somewhere. Maybe it was in Attorney Kellogg's. We're asking about seating capacity. Should we be asking about anticipated spectators numbers? In other words, I wonder if there was some comment that I thought I read where there's really, they're not focusing so much on horse racing, but rather on the gaming.
Yeah, she did mention a comment in there that one of the, somebody who was previously interested in building a track had made a comment in public that they didn't need to worry about traffic because there wouldn't be much traffic.
Yeah, I think that was the trigger. Yes, thank you for
yeah.
reminding me.
I don't know that a applicant going forward would say that, you know, and certainly on big days like Kentucky Derby Day, you know, as you've seen with Plainridge, they do get a large amount of interest and a lot of people do come. So
you think that whatever the seating capacity will reflect what they would anticipate as their largest number of spectators, right?
Yeah.
So we don't need to actually ask about the anticipated spectators. Okay, those are my comments. Anybody else have anything? Okay, moving on then to, and I think this is where section 3 and section 4 get confused, because I wrote, why is section 3 empty? Is that the old version?
Yeah, I think you'll see that what is identified as section 4 is actually the first, what should be the first question in section 3.
Is this application for a license to hold or conduct racing meetings in calendar year 2023? That is 3.1.
That's 3.1. I don't know how that happened, but that's why it's off.
Sorry, so I'm confused. Could you review that again? So section 3, schedule of proposed races should actually be.
No, so that's right. But then in the version that's in the packet, right underneath it, it says section 4 in highlighted language. That what is identified as section 4 is actually really just the first question under section 3. Because the version in the packet doesn't have any questions under section 3.
Is there a 3.2 or is the 3.2 just, and if you have a proposed schedule, please attach?
No, so 3.1 is.
Right, is
Sorry,
yes or no for next year?
Yes, right, so that's.
But is the
3.1.
current 3 supposed to be 3.2? Like, please attach schedule, proposed schedule if you have one.
Please attach a proposed schedule. Which.
According to page 6, it seems to be that way, Commissioner.
So 3.1, here's how I have it set up on mine anyway. 3.1, the question is this application for a license to hold or conduct a racing meeting in calendar year 2023? Check 1, yes or no. That's 3.1. 3.2 is pursuant to General Law, Chapter 128A, Sections 2, 4 through 5, and 3, an application must state the days on which it is intended to hold or conduct a racing meeting. That's question 3.2.
Wait, an application must state the days on which it's intended to hold. So, and that was the old, like, it almost looked like a footnote because there's a line.
Yeah, it does look like a footnote the way it's formatted right now.
Okay, so that becomes 3.2. What about the language that Eileen just referenced? If no, in what calendar year does the applicant propose to hold or conduct? Is that part of 3.1? Yes, that's the
That
no,
is
right?
3.1. That's the whole question.
Yeah, that's the whole question. Got it. And then that last thing under that line is the new 3.2. And then if you carry on over to, for me, page 6, submit as, and you'll just make sure all the exhibit numbers coincide with the sections, right?
Yes.
Okay. Is there anything other than that? That is new, that is 3.1, 3.2 complete section 3?
Yes, just those two questions.
Okay. Are there questions on that section? Those two questions?
But 3.2 is a critical question, of course, because this is one of the key issues associated with the award of a racing license is what days you're going to race on. So this does have to be completed. This is not something that can be conditioned in the future or anything along those lines, though the statute does say that they can seek an amendment of the allowed dates. So this is
Todd, can I ask you, if no, what calendar year do you propose to hold or conduct? Should be that a more robust question? Because rather than just getting us a year, should we be asking for what's your anticipated rollout?
yeah, I think
Here,
no, this absolutely. This is definitely the area we want as much information about that as possible. My initial thought was just that what is now 3.2, where we ask for the actual dates, that kind of outlines that very specifically when they plan on starting. But we can certainly ask more precisely too.
yeah, I think I'd want more than just the dates. I mean, if they're not ready to race the next year, I'd want more information about, or is there financing you're supposed to be getting? Are there, what's your plan? When do you think you're going to get it? I'd want more information than just some hypothetical dates, like 2 years out.
Do you want like also like even construction plan at like what date?
Yeah.
What's your timeline?
Yeah, I mean, if they say like, I can do this and we could do like one show race maybe in a year, but then it would take me, I'd want more than that.
I think we do have a question about, so question 2.5 asks for the proposed construction timeline. And
Okay, that's right.
2.9 gets into a detailed budget of the project.
So I guess I'd want to loop 3 into not just the calendar year. 3.2, I'd want to know, and please explain how your answers in 2 relate to how you see your live racing plan commencing, something to that effect.
Okay.
Could you just say that one more time, Commissioner, please?
I think I'd want what we're now is, it says section 4, but it's going to be section 3.
Yeah.
For 3.2. I'd want more than just the year.
Yeah.
I would want to know, and I don't know what level of detail, but we can harken back to whatever they answered in question 2 and say, in reference to your answers to question 2, please explain if you're not going to race next calendar year, what you see in terms of, what your facility, your amenity offerings and your racing offerings are going to be the following year.
And then under 3.2, the submission on exhibit, it says a statement of the date or dates on which applicant intends to conduct a racing meeting or racing meetings in the hours. So that gets into a little bit more detail, right?
Yeah, I just don't want someone saying, well, in 2024, I'm going to do, and they throw out 20 random dates with some hours. I mean, I'd like there to be some underpinning those representations.
Yeah.
So we can gauge whether it's realistic or whether they're just saying it.
And and the legal basis for this will be also memorialized. Okay, any other comments on this particular section? All right, then we'll move on to what must be section 4 then, non-commission approvals, correct?
That's right.
All right, so now this is where I think we were talking earlier about the local authorities, Todd. Questions for Todd on this?
I would, not to interrupt, but the only thing I would add, having gone back and looked at it in light of some of the comments, I might adjust what is 4.2 or could be 5.2 in yours. I'm
Yeah.
sure. That if you haven't gotten it yet, when do you expect it? I think we need to be clear that is a prerequisite to getting a license. So I didn't want to make it sound like, you can get it whenever you want. So I do think that question should be adjusted to make clear that it has to be received prior to any license being awarded.
Would you mind maybe even including it in the language under 4.1? It says, has applicant's proposed facility and premises been approved by local authorities in accordance with Chapter 128, Section 13A? I didn't go back, I'm sorry, to look to see what that actually means.
Like location and
And like,
selectmen
yeah,
approval and mayor.
is it zoning? Is it listed out precisely, or do we rely on them for all their listing of their permits? Because I would like to have them be held to list to us everything that we need to move forward.
Yeah, and I wanted the language to be less passive and saying, has applicant obtained all necessary approvals in accordance with?
I like both those suggestions. And Todd, the language you were suggesting be added to 4.1, it's already at the end of 4.2. We asked them to explain the present circumstances, including when they expect to obtain the local approvals.
Yeah, absolutely. But that does have to happen before the commission awards a license. That was my only.
So you might want to say it's a prereq or something more affirmatively. Okay. I think this is where I could really use guidance on what is actually a prereq. Am I right that it would depend on each individual site? In other words, it's not uniform, right? They could have zoning, they could have conservation, but not necessarily conservation issues. They could have historic issues, but not necessarily. All of those, and that's all, that's captured by statute generally.
Yeah, and we have that in 4.4, or what will be 4.4.
Yeah, that's right. Yeah.
Which it was a technique we used in the casino gaming licensing side, where we said on the RFA application, you tell us all the permits you need and when you plan on getting them. We didn't set out to identify all the permits for them and tell them how to do that.
No.
So
I want them to tell us, but I want it to be something that's like that we can rely on. Like they can't come back and say, "Oh, didn't know I had to get something from MIPA," or didn't know I had to get something from the community, the town's conservation commission. Didn't know. In other words, they have to have a fulsome.
Yeah, I think that's 4.4, and those are the exact questions I would ask if they submit something that doesn't include MIPA or doesn't include a building permit or things along those lines. We'd say, well, don't you need a building permit? That needs to be on your list. What is your plan for that? But this construct is such that they identify all of those things for us in the first instance.
Okay. Just a little nit in that 4.4. I think it's supposed to be any plans for acquiring them, or is it and? It says and. Applicant's progress towards any last sentence. Just a little typo.
Good.
The last sentence, yeah.
Got it.
Questions on this section 4? Commissioner Hill, this is familiar territory for you. Is there anything that you can offer for help here, or do you feel the same way that they need to give us the exhaustive list?
No, I do agree to that. I'm not ignoring any of you. I'm trying to go back into the Mass General Law and see exactly what it is that they have to
128.
do.
Right,
Yeah.
under
It's like
120.
mayoral and city council, town council approval and things like that. So
Yeah.
it doesn't go into the level of detail in terms of necessarily the building permit and, it doesn't go into that level of detail.
No,
Yeah,
That's
that's not.
exactly right.
Oh, sorry.
Yeah, I was just going to say, section 13.a is just the city council, town council, mayor has to approve of the location.
Yeah.
That's all it is. It's not any other permit, zoning, anything else like that. Then section 14 is the county has to have voted in support of having racing in that county at some point in time. And then this 5.4 is the commission's discretion. This is additional information you're looking for. This isn't required by statute.
And that's okay, right? We can go beyond the statute? because of
Absolutely.
that? Oh. I like it.
Well, I will say
I know
that the statute specifically says that in an application, the commission may ask any questions it would like. I'm paraphrasing, obviously, but you're allowed to ask.
And that's why it's good to include that in the memorialization for legal. No, it's okay.
to be clear though, just so we're all clear, if a town, so for example, a town select board, I'll use that because that seems to be
Yeah.
what we've been getting used to lately. If they vote no right out of the box, does this application now become moot?
Yes.
So we
There
don't-
is a process by which the town can override, but yes.
but that we don't have any authority to circumvent a vote of the Board of Selectmen. Not that we would, I'm just saying that to be fair to everybody. Okay,
So to that point, does it make sense to require the approval before the application is even submitted? I mean, I know the question is framed in such a way that contemplates a later submission. And I'm speaking of 4.2. But do we want to, I think, Todd, you made this point earlier, revise that question to have the approval of the local community be absolute?
So the approval does have to be absolute, and it does have to be before the commission awards a license. But in recognition of the October 1st submission deadline, I think it makes some sense to allow some flexibility as to when it actually comes in. But it's not a flexible requirement.
And the October 1 deadline is applicable to new applications as well as the renewal application?
Yeah, to all applications.
I think, go ahead, Commissioner Maynard.
I apologize, Madam Chair. Thank you. So Caitlin, just to get to your point, we can ask additional questions. So if, for example, I wanted to know the last time a select board voted not to move forward, or the community voted not to move forward, that's something that we could do and not have to add it into the application.
Excuse me, I apologize. I believe that you would want to include it in the application. If you give me 1 second, I can find the wording. So 128A section 2 says that the commission can ask in an application for the answers to such other questions as the commission may prescribe. So if you wanted that information about prior actions of the town, I think it would be best to include it in the application. But you could probably also ask it at a roundtable or something like that.
I would be interested in that, but I don't know how the fellow commissioners do.
Commissioners?
I don't have a problem with it.
Okay.
So Commissioner Maynard, just to make sure we get this exactly right, can you just restate what the question is you'd like to ask?
Please explain, so you could really drop it into 4.2, right? You could even make it part of that. You could also say, explain any recent votes or any votes, right? That were in the contrary, right? So you're basically asking the inverse question. You're asking, have you, has this went to local approval? Have you not been approved locally?
do you want to say, have you ever been denied
Have you ever been denied local,
local approval or?
Yeah.
Or
If so,
failed to receive, yeah. Because what you're looking at is the history. And then there would be some kind of a referendum or else a new vote in order
And
for them to get approval.
sorry, I apologize. I was just going to ask, this is specific to this application, correct? We're not asking for the history of the applicant. Have you been denied in another town for another project? It's have you ever been denied in the town for this license, correct? Or for this location?
That's what I'm interested in.
Okay, great.
I think it goes to viability, and that's the reason I'm asking it, right? If you just lost something, that weighs in on us.
It's important history for us to understand. I appreciate that question. Anything else on this section? Commission on local approvals. This is just on 5.3 is the county one. 5.4 is all of them.
4.3 relative to county approval, do we want to mirror 4.2 in that we're looking to know, if not, when do you expect?
Yes, I think absolutely. They're both mandatory. So they should reflect one another. I agree.
Yeah, we can change that, although I would say it's probably, because of the whole process, you need to get something on the ballot. It's probably unlikely that it would be within that 6-week period, but I think we can definitely make that the same.
They probably, yeah, and
Or is it scheduled? You could ask, if not, is it scheduled? And if so, when?
if I remember correctly from the one that we heard, I think it was last year, there was a very, am I wrong? A very old county approval that was relied upon?
Yep.
And we would just want the proper documentation of that too, right? So they just need, they understand this is really a critical component, both the local and the county and any relevant federal and state. And it's on them to be.
Do we also want to put in there and some sort of requirement that they aver to their knowledge that the vote hasn't been superseded since then? I mean, somebody could give us something from 1954 knowing it was rescinded in 72, just be silent on it.
To my point, thank you, Commissioner Bryan, that's the right follow-up. I want to make sure that we don't have to do that.
Right.
It's on them to show it's a valid approval. Yeah. I'm presuming the local are likely to be more recent, but that might be a wrong assumption. So the same thing applies.
Well, no, I think your instinct is actually right. I think that the local vote has to be recent because it's about the specific project. The county vote is just whether you're okay with a racetrack being in your county. So that could have been from 50 years.
I think that prompts the question, is it still valid? Like,
Yes, we've researched that issue. We can include that.
In the legal, yeah. And I thought that you'd done that last time, so thank you. Any other questions on this section for local non-commission approvals?
4.4, yes, 4.4, thank you, Madam Chair. The note at the end of the question, I think, could be clarified to specify that the approvals are the ones that are referenced in that particular subsection 4.4. So in other words, it's not reading as though the commission can issue a conditional license on the local approval piece.
Yep, got it. Good point.
Very good point. Okay, then moving on to section 5, qualifiers and stability. Did I miss anybody? I'm sorry. I found the other. Okay, then.
Oh, that's the dog barking outside. I'm sorry.
No, at a certain hour, we all sort of sound like that, right? So section 5, qualifiers and suitability. Questions for here? I had just a general question, and we have, I think, an opportunity here to just check in with IEB on this. I presume you went back to the when you were just setting up the casinos, Todd.
Yeah, I think that's where a lot of this comes from. I think it's important to recognize, though, that while the statute and the case law are clear that the commission can and should require some type of suitability review prior to awarding this type of license, there is no direction in the law as to what that process should look like. And we, of course, have a very effective program that's been put in place on the gaming side. So one of the questions is, do you want to mirror that? Are we going to use the same standards? Are we going to identify the same entities and individuals as qualifiers, or take a different approach? And that's all set out here. This, depending upon where the commission is leaning, we could shorten this and just say something like all qualifiers have to submit the same forms that they have to submit on the gaming side. And then we don't have to ask all these questions. If you're not inclined to use the existing forms, then we would want to include all these questions, because most of these are contained in the existing forms.
Well, I'll just start off. If they get a license, and we keep on using the term they, which if an applicant gets a license under 128A, they absolutely have a right to a mobile app for sports wagering under the new statute, correct?
I pause on calling it a right, but it's pretty close. Yeah,
they get
I get it.
access to it versus, sorry, wrong language, 23N in rules and regulations, as long as they comply with that. There's no cap, there's nothing. They have access to getting it.
Yes.
My instinct is that's probably what will be a big motivator here. So there might be some efficiencies if we ask, are you going to, in the event you're awarded a license, are you going to pursue a mobile sports wagering operators license? And if so, you should have the same suitability stuff done so that we're not doing it twice, right? Thoughts?
I like that idea.
Yeah.
Commissioner
Alex,
Maynard,
if you-
I missed you too, sorry.
No, I agree.
I mean, I guess it could be a check, nope, not gonna go for it until they do something different, but
That does seem unlikely. I guess we have to just think about the timing of everything, and when it is going to be that the sports wagering application will be issued, and what the timing of that suitability review will be relative to the commission's review of this application.
And
because
I
we
would
have to
also,
decide by November something. Okay, got it. Sorry, Caitlin. go-
I would also just say that I think it's an open question as to if someone is seeking a license for 2024, 2025, if they have the ability to seek a sports wagering license right away, or they have to wait until their license is actually effective. So there could be a big gap between applying for a 128A license and then applying for a sports wagering license.
So that's an interesting question, Caitlin. You're distinguishing an effective license versus a conditional license.
Yes.
We haven't talked about that.
And I'm not sure that that's something that Todd can jump in. I'm not sure if we're prepared to talk about that today, but I think it's an open question.
Commissioner O'Brien, when licenses were awarded to casinos, they were conditioned, but they were effective at the time they were awarded, correct?
Well, and then you had the, Todd, help me out, the verbiage for actually being able to open the doors.
Certificate
The
of
operations.
operation.
Certificate.
Right. And so you had your license was effective, but that didn't mean you could open your doors till you get your operation certificate.
Oh, is that what you're getting at, Caitlin?
Not necessarily. Um,
But there are license conditions. I mean, we attach them also to the operation certificate, because I know like with EBH, there were a number of things we were trying to sort out, and some of it beyond their control in terms of did MassDOT get the monies they were supposed to get. MassDOT hadn't set up an account, it was outside their control. We didn't want it to get lost. And so those conditions were attached. And Todd, maybe you remember this better than I do. I thought they were attached to both, like they were kind of keyed in. They got the operation certificate, but subject to the conditions that were attached to the license.
That is absolutely true. And that is a great distinction to draw. Although I don't think it really gets to the heart of Caitlin's point, which is just whether you would consider that entity, even though they can't operate a sports wagering operation or a horse or live horse racing, whether they would be considered under the statute to be a holder of a 128A license, even if it's conditional.
Well, I mean, Kathy, think back to the Wynn hearings we did, right? I mean, they had a license, they were a holder of a license. We did a hearing to revisit suitability given information. I mean, they were treated like a holder of the license, right?
Yeah, no, I guess I agree with that, Commissioner O'Brien. I guess I would be really interested to see that legal analysis in writing, Caitlin, where there's a distinction of our awarding. Well, when do we give it to them so they're holding it? Like where's that gap? Is it the
conditional versus a
conditions?
final.
Conditions? Is it because of the effective date of this, when they're going to, I would have thought that the awarding meant that they now hold the license. It's just conditional. And that's why the conditional question is so big. But that's a really interesting point. Commissioner Maynard, looks like I think Commissioner Skinner, Commissioner Hill.
Just a
Thoughts?
question, whether you're issued, an applicant is issued a conditional or full license, they'd still have to be reviewed for suitability, right? And that would have to have been done before any license is granted. Is that right? Todd is nodding his head. So I'm just a little confused as to how this discussion relates to the section we're on, qualifiers and suitability. I may just have like a brain fog.
It might have been prompted by my idea that could we use the suitability, whatever we are going to be expecting, and Todd raised a good point. There might be some time issues because will we know what we'll be expecting for suitability for sports wagering in a timely fashion? I'm hoping so. Would we have them go through that? If they are inclined to want to be a sports wagering operator, mobile sports wagering operator, just have them go through the suitability standard that could then be applied to the 128A section and then not have to redo a full suitability study. So I think that's what prompted it.
Yeah, and I think Caitlin and Todd were concerned about the time lapse between the two. The two events. But right now, when
also
it's
I
right
don't
now,
know.
when IEB does the suitability reviews, it's a one and done, right? And unless some event, something happens in the status of the qualifier, right?
Yeah, I mean, obviously suitability is ongoing, but yes, there is a moment in time where a decision is made as to whether someone is or is not suitable, for sure. And that would have to happen here. So perhaps what you're all getting at, which makes good sense, is for us to look to the language in 23N related to suitability and see if we can really just make use of that in the racing context. So whether we do it in advance of any 23N review or at the same time, that they don't have to resubmit the same documents, that we're looking at the same individuals, we're looking at the same entities, and we're applying the same standards. And I think that does make good sense, and I think it can be done. That can be done.
So it is a little after 2. I know we had a hard stop at 2.
Yeah. And that was section 5. all the suitability standards. Section 6, we touched on it in the public interest. I think what I would suggest on section 5 is maybe working through the issues that just were raised, and then also checking in with IEB. Other suggestions in addition to what we raised today, just now, I mean? If there's deficiencies that could be built in, and it fits in the legal construct, we should try for it. And then the public interest is section 6. Any questions there? Alex, are you okay with section 6.2 with respect to the executed agreements with all the representatives, horsemen's organizations? Does that work? Is that consistent with what we do now?
So Madam Chair, are we going to continue to go through, or are we
No.
going to?
I just
Break.
wanted, I think we're almost there. So I was just looking at public interest, if there was anything that jumped out at us, if Alex looked at, and then we already looked at, we didn't look at facilities and equipment, but I wondered if there's anything that was really something that we could mention now. And then otherwise, I think we're good on section 8. So we kind of got through.
Yeah, I think we're done. The only other question I had that I picked up from one of the commenters was a suggestion that there be some requirement that the applicant identify how they will provide for the welfare of horses on site and their aftercare and things along those lines. I think it's obviously an important question. I think, and I'm kind of going out on a limb here, but because I'm not 100% sure that this is covered in some way in the existing regulations and how the animals are treated and the type of medications that can be administered and things along those lines. But obviously, this is an important issue. The question is just whether it's something to put in this application.
Todd, if I had my way, we would put it in the application. I know it's in the regulations and how you're supposed to treat horses, but this is a huge issue. And actually, a couple of people have asked me about that. I have no reason why we couldn't put it in. And I know you could show us what section that would go under, but I'd like to see it in the application, actually.
Me too.
Okay.
Anybody else? Commissioner Maynard, were you nodding your head as well? Yeah.
I think I had it kind of earmarked for the end of section 7, but we can take a look at that. I mean, it's not directly related to facilities and equipment, but I think that was the closest place.
Thank you.
Or public interest. I mean, I think we want to always make sure that the animal athletes and the horse community are all, their safety is paramount. Bring the regs up in, I'd be okay with that too, you know, as a guideline. Is there anything else? And I'm glad that you raised that because I did know, now we're short on time, but we've got to now come back with a revision, and Crystal and Jacqueline will have to work their magic to find how we revisit this. Commissioners, other questions, comments?
I think if possible, and I know we're running on time, but I'd like to really know today what the next step is and when this will come back to us. Because I'd like to see it done.
Crystal will talk to us about timing, and then of
Okay.
course there's some work to be done on legal. Crystal, have you been able to find a time?
How far in advance is the October date still a hard firm date?
October 1st is the deadline.
That's when it's due. So, I mean,
Right,
obviously.
so
we'll
that's
need
what I'm
some
saying,
time to look
how
at.
far in advance of that date do we need to have a review? I think. I'm looking
Is it
at
our
some-
goal to have it done by October 1st?
It's statutory.
Madam Chair, is it too much to ask? And legal to have the item taken up at the September 8th meeting? Would that be reasonable?
We have the 8th and the
And would
15th.
that allow for adequate time?
I don't know that there would be time.
Well,
Based-
Krista, let's
How
think
about
about
the
this.
15th?
But I was going to say, I do think there would be time on the 15th.
What about
Oh,
September 7th? September 7th is an agenda setting meeting. What if we added it on before the either truncated agenda setting and then do this after that, Crystal?
I think we might be able to, there's a lot of internal movement.
That's fine. We can
Just
deal.
Also, I just someone is on vacation, right?
Yeah. I was just gonna-
Oh, that's, yeah.
And then it's into Labor Day. So there's only like one day after Labor Day too, before that vote would then happen.
Good point. So September 8th, we're gonna start with sports wagering. That's gonna be a good fulsome discussion. And then we have about an hour and a half of, we probably can't do that on that day.
Yeah.
What about the, Madam Chair, what about the holds we put just today on Tuesday, August 30th, Wednesday, August 31st?
I don't know, because of other internal staff schedules, that's meaning that this is due the week after next, right?
Internal
Right.
stuff
We
can
have
be,
vacations,
we
right?
can, if it's internal.
No,
stuff-
I'm saying, yeah, I just don't know what staff are available to make all of the
Right.
changes.
Right.
So on the 8th, I have a hold for in the morning, that's from 9:30 to 12, but then there's also a public meeting
You
scheduled
have
for the
two
afternoon.
public meetings. Yeah, so
Okay.
in the morning, you'll have the sports wagering part, and then you'll have a big break, because that's going to be a lot of information to digest and to process.
What about
General,
September
and then
9th?
the
What
meeting.
about September 9th, Fridays? Are we using up our Fridays?
I'm
September-
available.
I think you still have someone on vacation.
Oh,
Yeah.
I'm forgetting. I'm so sorry, Jordan.
But listen, if we need to make something work, let me know, I'll make it work.
I
Yeah,
think.
but I think if we go into the, what about early on
Yeah.
the 12th or the 13th? Like,
You have 3 meetings that week, but if you want to take this up and you think it'll be a couple hours, we could
You need
add it.
to.
well, there's a
You have an
deliberation in there on the
executive
13th, right? That could be moved in theory to accommodate getting this out on time, right? Or more expeditiously, I should say.
Let's do the,
I don't see that, but I was thinking on the 12th, when you already have the executive session. you
yeah, the
could
executive session,
move
could
the
be pushed. The executive session could be pushed after the licensing. Let's start at like 9:30 on licensing if everybody's available on the
Well,
12th.
I'm just wondering, Jordan, when do you come back from vacation? I said, I'm just wondering if it's easier to do it like the next day at 11 or 10 as opposed to throwing him back in.
No, I'll be back on the 10th.
Okay.
Saturday the 10th, so.
He's gonna have memorized this on the plane.
I will have rest
Speaking as
before-
someone who's going to be doing that about 3 weeks later, not totally altruistic of me to make sure we got a buffer in there.
I appreciate it though.
So what about like just sticking with the 12th and starting at 9:30 to 11:30, and then we follow up with an executive session right after that. And that's the litigation update.
Does that work for legal schedule? Just want to make sure, because we need them.
I've got my whole day open that day, it looks like, so.
I know, when we start doing these, it then moves past to make sure we have legal. So.
Yeah, so we can
Oh, the
have a break.
executive session is available, but,
Let's use the 12th for anything we need. It looked good for everybody pretty much.
I'm just wondering, if we did 10 for the executive session, because I know that A&K is available at that time, and then
right.
kept it short and then went into a public meeting after that at, or the executive session is at 10,
At
and at 11 went into a meeting on this.
That works for me.
That's fine.
That works for me, except I have a 1 o'clock that cannot be moved.
Works for me.
So 10 to 11,
Wait
11
a
to 1.
second, we've got a 1 o'clock that can't be moved. So the
10
litigation
to 11.
update is at 10.
Lunch till 1.
10 to 11 and then 11 to 1. Should work, right?
Yeah, but is it, do you need time to get to your 1?
No. It's virtual, so that 1 o'clock will be 10 to 1 is fine. It's not my meeting, so when I say it can't be moved, it can't be
No,
moved.
I
by me.
understand.
That's
No, I
what I
understand.
mean.
I just want to make sure we didn't have travel time involved. That's all.
Yeah.
Because I want to take that into account. Okay, just double checking.
Okay, so 10 to 11, keep the executive session, which works well, and then 11 to 1, we'll schedule the race. Okay.
Okay.
All right, are we good to move?
I have to say I have a little reservation because the executive session isn't the priority, unless there's a time factor for that, is there? I just want to make sure we don't run into any time factors on getting this done.
No, if you'd prefer to have the racing application meeting at 10, I can contact A and K and just make sure that they're
Just
available.
check to see if we could possibly flip it, I just want to make sure that we don't shortchange one, so, that's all.
I would, just from a scheduling perspective, if you start with it and get it over with, then you don't have to worry about ending the racing one at a certain time. I mean, you do, because you have a hard stop. So either way, I guess it doesn't matter. Okay.
Well, and for that reason, I would suggest starting at 9:30 on the 12th.
That's exactly right, what I'm thinking, 9:30 for the licensing and see if A and K can, that's really, I'm much more comfortable with that, particularly with the 1 o'clock sharp deadline, which actually I thank you for, Commissioner Skinner. It's very helpful. We'll be able to have a nice lunch break exactly by that time. So
I'll book the 9:30 to 11:30. Caitlin, could you just get back to Jacqueline and I with confirmation from A&K?
Absolutely.
excellent. Thanks for going back to them. I'm assuming that hopefully they don't have too bad of a schedule. So thanks. All righty. Anything else, commissioners? We ran a little bit long. Todd, you all set?
Ready to go.
Feeling like this was productive for you?
Absolutely.
Okay, and thank you, Dr. Lightbound, you're all set? Caitlin, you're all set? Karen? All set, all right. Hey, Jacqueline, thank you for staying on. Crystal, thank you for all your guidance, and David Mills, thank you. And for those of you who joined, we appreciate your joining us today, and I will need a motion to adjourn.
So moved, Madam Chair.
Second.
Okay, any discussion? All right, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner
Aye.
and Commissioner Maynard.
Aye.
And I vote yes, 5-0. Thank you, everyone. Appreciate it. Great work, team.